Could talk about the trial where go begin again on the 26th of July. Yes. How prepared Nnamdi for that trial?
Well, we are, but there's not going to be any trial. There's going to be trial within trial. What happened to Nnamdi Kanu is, by legal definition, worldwide legal definition, what is called extraordinary rendition. It's a state crime. It's a crime by the state. If a private individual abducts or violently and illegally seizes another individual, it's called kidnapping, and is a very, in some jurisdictions, is a capital offense. When state does it, it's called extraordinary rendition. That's what happened. So if you rendered or you renditioned a fugitive or a suspect, you have lost jurisdiction to try that suspect because you committed an international crime. You broke your own laws. You broke the laws of the third state from which territory you renditioned that individual. And you broke the laws of the second state of nationality of that individual. That is what is playing out here, because we have three divergent but also compliant jurisdictions. The three jurisdictions here, Nigeria, Kenya, and UK, their laws prohibit extraordinary rendition. The only legal pathway to grabbing a suspect from one jurisdiction to another for for UK, for Kenya and Nigeria is through extradition. It has a process. Nigeria has an Extradition Act, which you can find at the Laws of Federation of Nigeria, Chapter E25. Kenya has its own. It's called Extradition Commonwealth Countries Act. Britain has its own. The three laws are very similar. So there's no conflict of law here. The only conflict of law is that Nigeria chose to break its own law, Kenyan law and British law. So that conflict will be ventilated in court to see whether there is jurisdiction to try him for any offense, or whether the proper thing to do is it not to return him to the state that he was. Despite the bench warrant that was issued by the Federal High Court here, the bench warrant is not a competent legal document to go into a foreign country and illegally grab a suspect. It's not. It should have become one if Nigerian authorities had submitted the process to extradition proceedings in Kenya and succeeded in the final analysis in getting a warrant or order of extradition. It would have been okay. So the first issue before the court here is not to try Nnamdi for any criminal offense, but to have a trial within trial, because extradition is, of course, is an act of forcible abduction, so it's considered torture under the Torture Convention. And Britain has case authorities where it has asserted extraterritorial jurisdiction, what is otherwise known as universal jurisdiction, to indict and try and imprison those that engaged in such conduct. And if Nigeria was lucky that this didn't occur on British soil, if it did, we would have had a throwback to 1984 when Nigeria tried it.